Thank you everyone for being here. It's been really wonderful to have you here. I have the pleasure and honor of introducing the next panel, which will focus on trauma and civil litigation. And I am delighted to introduce this panel, Miriam Weizenbaum, who is an attorney at law with DeLuca, Weizenbaum, Berry, and Revens. She has a long list of accomplishments. I will just touch on a couple briefly. In 2016, attorney Weizenbaum and her partner, Amato DeLuca, founded the Rhode Island Center for Justice. And since its founding, the center has been fulfilling its mission to protect legal rights and ensure justice for vulnerable individuals, families, and communities through partnership with community advocates, while training and mentoring future public interest lawyers through an innovative fellowship program. And I also want to very briefly thank Students for Civil Justice for partnering with us on this panel and helping us with securing panelists and promoting as well. So without further ado, Attorney Weizenbaum, I'll turn it over to you.
Great, thank you. All right, that worked. So I have to move that down. I have the privilege of introducing our panelists, and I think what you're going to hear from the folks who are up here now is a kind of on the ground civil litigation experience that's sort of not as specific to the communities that I know you all have heard about up to this point. So I think that's going to be an interesting conversation among trial lawyers, former trial lawyer, and now judge. So I'll start with Judge Keith Cardoza, who's an associate judge on the Rhode Island Workers' Compensation Court. Of course, I have to start with the judge because I've been a trial lawyer long enough to know you don't skip over Judge Cardoza practiced for a number of years. In fact, he was a founding partner of his firm, engaged in cases involving injury to workers. From there, he went on to the Workers' Compensation Court in 2019. And in addition to handling cases in the context of workers' compensation, also has made numerous and continues to make numerous contributions to the bar through organizing with the Rhode Island Trial Lawyers Association, the Legal Education Foundation, and other activities. So very important to for those of you who are not yet practicing to what you will be doing. I'll next introduce Austin Dana, who's an attorney at Keches Law Group. For those of you who don't know, Keches represents people who have been injured by doctors and products, and so is representing people on a regular basis who have experienced injury under circumstances that can often be traumatic. He is currently, and I want to mention also before that, was a practicing attorney at the Public Defender's Office in Springfield, which, having been a public defender myself, I know is really like being a prosecutor, is on the front lines of a lot of the hits that society seems to leave people with. So you've had deep experience in a couple of different directions. And then Jonathan Orent is, am I pronouncing your last name?
Close enough.
Okay, I got to ask you. Anyway, he's an attorney at Motley, which is a national law firm that handles very, very large and impactful cases. Jonathan's handled the some of the hernia mesh litigation, other defective medical devices, pharmaceutical drugs, and I'll also note has represented clients in the forefront of emerging cases, which requires looking at the effects of social choices looking at those differently, which also means, I think I'm going to just speak for you. It means it requires one to think differently about the effects of many social activities differently in how they, and which is another form of understanding trauma. Um, Jonathan's also an adjunct professor here at the law school. So we've got a great group, and I'm going to jump in. Again, I'm going to start with the judge. Judge Cardoza, as a workers' compensation judge, you're presiding over cases that involve serious injury, questions of causation, credibility. How do you balance being fair to the process with the fact that the people before you have themselves experienced a traumatic event that's caused injury?
It's difficult to do. I take my balance for impartiality very seriously. So the first thing I like to do is to prep the people who will be in the court for that particular hearing or trial. So I'll let my sheriff know there's someone who has a traumatic injury that's going to be appearing there. I'll let my clerk know, the stenographer know, so the person can have extra time. Essentially prepping the courtroom for that person who's going to present. I am of the belief that I can acknowledge the severity of the injury without casting any decisions regarding causation. So I can see the person's missing a limb before me. I can acknowledge that. I can acknowledge that it's very difficult for them to tell that story, to provide a history of what happened to them, and give them all the time they need to tell their emotional story without casting any, you know, comment on causation at that time. So I just think it's important to make sure that they're heard. The only time it gets slightly complicated, and this is something that you deal with from the bench, is when I have a series of cases that are essentially traumatic brain injury cases, where the defense is essentially arguing that the person is making up their their injury, and then so you're faced with one side who's like, this is make believe, and then I still have to acknowledge that this person is stuttering and having difficulties, and they have an expert indicating so. And I'll still indicate that they have these limitations, and I'll treat them accordingly, even if in the end I'll decide against them. The only other thing I would add is a lot of times I have to cast aside any of the things that a lot of judges think they're good at regarding tools to determine credibility, reading people, eye contact, all the things that empirically probably you really have to throw them in a dumpster when you're dealing with someone who has a really traumatic injury, because they're telling a story where they suffered these injuries and they're trying to explain how it happened to them. And you have to understand that perhaps their injury is so severe and their recovery has been so kind of arduous that their history of what happened doesn't come out in the initial medical records, and it isn't reflected in their first visit. So a lot of times it just involves kind of washing away all those lie detectors that a lot of us judges think we have, and just going in and letting the person try to convince me based on the evidence.
So I have to ask you, is that something is that a realization you came to yourself, or was that part of the training as a workers' comp judge?
That's a realization I actually came to being a defense attorney, and I struggled initially being a defense attorney on some of the horrific injury cases where I would have to depose a surviving spouse or a person, and it really explain to them, I understand that, you've been through something traumatic. I'm not saying it didn't happen in this case. I'm just trying to determine if we're responsible for it. And kind of learning to do that over, I didn't learn that initially. I struggled with that. But doing that over, hundreds of depositions allowed me to kind of pick up some of the tools. And then I had to develop those a little bit more on the bench with regards to realizing I'm not a lawyer anymore, so I can't wade into these skirmishes. So I think it just really comes from acknowledging it's something I had to work on and experience.
I just want to note, like a practice pointer, it is so unusual for a judge to recognize that what you think of the normal indicia of credibility may not be reliable. That is so, in my experience, very unusual. But I want to note it because as you're out there practicing, it's legitimate to raise that with a judge. I know that can be scary. Maybe you want to, get a senior attorney or your, supervisor behind you. Maybe you want to file a memo in that regard, but I want to note that. Let me go on to Austin. So you've had extensive experience in serious injury and wrongful death cases, including police brutality cases. And I wonder what trauma-informed practices you have developed that integrate into your civil litigation strategy.
Sure. I think a lot of that starts with the fact that what we're really trying to do to effectively do work for plaintiffs is to understand what the human story is and to be not only their attorney, but they call us counselors because we kind of become that for our clients. And you can't do that unless you know who the people are. And I think what it boils down to, in a lot of respects for me, is getting to know my client and listening to them and understanding what they've been through. And that doesn't happen when you call them into the office for the intake the first time and they're sitting across the table and you have a notepad out and you're asking questions off that notepad. Who's responsible? What are your injuries? And what are the ramifications of your injuries? You really have to put the notepad aside. You have to go out to the client's house. You have to sit with them, have a meal with them, and you have to spend a lot of time understanding what the trauma actually is and what they're experiencing. And I think the judge spoke to the fact that the trauma is not always going to be right there in your face, especially if it's somebody with a traumatic brain injury, or even if it's just an injury that you can actually see. It's going to be a lot deeper, and it's not going to come out in that first meeting, and it's not going to come out if you're sitting there asking the lawyer questions. So one way that I integrate trauma-informed lawyering really comes down to listening and getting to know the client on a human level, on a personal level. And then that translates and allows me to effectively represent them in court. Because you can't tell someone's story if you don't know it. And you're not going to know that person's story if you're just taking down notes in one meeting and then walking into court or getting up in front of a jury. You have to really know these people in order to be able to advocate for them. So I think that's how trauma-informed lawyering really impacts the work that I do.
Yeah, thank you. Let me go on to you, Jonathan. In cases that you've had, and I'm thinking of the Boston Scientific litigation, which you may want to give a thumbnail of, the key evidence can be traumatic for your clients to re-experience. And I wonder how you manage presenting the necessary information and maybe not re-traumatizing your clients. How do you manage that?
So for those of you who don't know, what Miriam is referring to is essentially the transvaginal mesh litigation. I was very involved in the origin of that litigation and litigated those cases for probably close to a decade, from the beginning to the ultimate resolution. I want to just first mimic what my colleague just said, which is listening to your clients is so important, understanding their story. From a practitioner's point of view, what I like to do is, once you build a rapport with your client, let them tell their version of the story uninterrupted versus peppering someone with a lot of questions. Part of what the client needs to understand is that it's truly a safe space to be open with me, and that my interest is in protecting them both vis-a-vis the rest of the world, but really in conjunction with the litigation. That helps when we walk into a deposition or a trial by talking through certain issues with the client. So in a case that involves injuries to, in the case of vaginal mesh, the vagina, which is obviously issues of sex arise, a lot of the defenses to that result in things like asking questions about the quality of the person's baseline sex life, getting into abuse issues, whatever it might be. So one of the things, part of a good job in advocating for your clients, is understanding both what's relevant to their story and what other things are involved in that person's life that they may not want to talk about, and perhaps pulling a defense lawyer aside and saying, hey, here's the boundaries. If you can respect these, we're fine. If not, we're going to get the judge on the phone before we begin, before we start the process of putting this person's most private part of their life on the record. Letting the client know where the boundaries of confidentiality are. Walking that client through so that they understand that there are protections in place for their confidentiality to be maintained, that these records can't be just put on the internet somewhere, unless or until that person goes to a public trial. So there's a lot of counseling that goes into it, and a lot of that work is done on the front end. The most important thing, though, is understanding you don't want the process to victimize or re-victimize your client. And so understanding where sensitive areas might be. Let me give you some other examples. There may be times where a person wants their spouse around them in the deposition, but there may be opportunities or certain points where you don't want that spouse there. This person, the last thing that they want is some private healthcare information that maybe their spouse doesn't know to be disclosed in a deposition to their partner because they're sitting right there. There's a whole host of things that we can't imagine that someone goes through, whether it's the actual physical trauma or perhaps it's the guilt that they have about something. That our job is to understand the client, what makes them be most comfortable under a very uncomfortable circumstance, right? Giving testimony is uncomfortable no matter what you do. So your job is really, as a lawyer and an advocate for that person, is figuring out how to make the best out of that situation and control the environment and make sure that it is as comfortable for that person as it can be under those circumstances. Setting up a series of ground rules for that to happen and enforcing them with opposing counsel.
Yeah, thank you. Well, let me throw it back to you, Jeff. This is civil litigation's adversarial process, right? So, and you've got people who have self-selected to, well, fight. So how do you manage that? Have you had situations in the courtroom where you feel like the aggression is at a level that is in itself re-traumatizing the litigant, and how do you deal with that?
I experience it quite often. The nature of workers' comp is some people have employees. This is a relationship. They've worked for the same place for 30 years, or this might be. I had one recently that resolved. I can speak about it, but people were in the same family. So the only other business was there was a cousin, and they felt like you shouldn't have filed the comp claim. The reality is that professionalism sometimes isn't there, and I have to wade in and there's a difference between fighting a case and defending it properly and being what I think is unprofessional or insensitive. And I never ever disarm an attorney from using all their tools at their disposal because they have a client to represent with regards to conveying that someone is making something up. Or the reality is usually embellishing or making their injury seem worse than it is. But I explain to the lawyers, usually in private at first, I don't really care if you necessarily respect each other, but you're going to respect my courtroom. And in my courtroom, you respect each other. And usually I won't have any issues. This usually happens in situations where the lawyers already have a pre-existing relationship and they frankly don't like each other. So you usually can identify really early when an employee hate each other, and I'm going to have multiple sheriffs there, and we're going to have to go through a slow process of explaining to people they will go to jail if they're not nice to each other. But the reality is it's usually the lawyers that dictate how it proceeds. So one meeting with counsel and saying, listen, do your job but keep it professional usually means that their client's on their best behavior. But it usually comes in terms of belittling the person's trauma or saying they made it up or it never happened. And it's fine to say that you think that an incident didn't occur as long as you do it in a respectful manner and the evidence demonstrates that. It's when it becomes personal that I intervene. So, it's just, there's unfortunately for lawyers, a lot of times this is in the gray area, right? Like, I have to be able, if I'm counsel, to accuse you of not being honest about where you sustained this injury, or not being honest about exposures you've had that you haven't mentioned in your deposition, I can do that and call you a liar without saying liar. I can just indicate that it wasn't reflected in your earlier testimony, and you didn't mention these medical appointments you had 20 years ago, did you? Okay. And I think that comes with professionalism. And I would love to say young lawyers do it worse or lawyers with experience do it, but the reality is some people just have an ability to convey information and call you a liar in a nice way and still resolve a case, and some people don't. I think that's just a learned trait. But I just try to police it the best I can without stopping the lawyers or restraining them from doing their job, which I think would be a real violation of my duties if I went that far.
Can I add something?
Yeah.
Actually, I think that's a really interesting perspective. And when I counsel my clients and prepare them for trials, one of my jobs is to prepare them for all circumstances that might happen. And I'm actually a practitioner of mindfulness personally, but I also bring concepts of mindfulness into my witness prep, because I think the best witnesses are the ones that understand that people lie and embellish the truth for the most part. There are some people who are just true liars, but most people embellish or exaggerate or provide unnecessary and maybe not true information when they think that either they're looking like they're dumb or being called a liar, oddly enough. Those are the primary two circumstances that I've seen when people embellish or retreat from the truth. And so if people understand that just providing literally the simple truth and they don't move away from that's sort of liberating. And they understand the judgment that's being put on them, it tends to release some of that pressure. And so I tend to spend hours working with each of my clients in preparation for their depositions, in preparation for their trial testimony, teaching them how judgment can affect their answers and how that they need to just take a second, figure out what questions really being asked of them, and then answer with what I call the simple truth, which is if you can answer just as simply as you can in one or two words, that's all the truth. If you find yourself going on and on, you're probably making something up. So anyway, that's how I approach that.
I'm sorry, I want to add something to that and to something you said. I've noticed being on the bench that some lawyers, unfortunately, they're not doing what these two lawyers are indicating. They're not listening to their client and meeting them where they are. Every client's different. The tools we're giving you or talking about, they don't work for everybody. And the example is there's plenty of people who appear before me that find it very demeaning, depending on how you address their level of injury or the severity of injury or their limitations moving forward. So you have to meet that person where they are and describe it. If they're your client, you don't have to meet them where they are if you're on the other side. But you certainly have to meet them where you are if you're a client. And I noticed a lot of lawyers who start a trial, our trials are bifurcated, they'll go over 6 months to a year, and they'll talk to the person almost as if they would have preferred to be talked to. And then you notice them realize that this person's not responding well to that, which I think you should have known if you prepped your client properly. And then you see them pivot and realize, oh, I have to talk to this client the way that they will best respond and get their story out. So I just want you to be careful when you get all these tools that you don't do a one size fit all if you're at a busy practice and say, I'm going to be very sympathetic. You had this traumatic injury, you were mutilated, and the person's like, there's nothing wrong with me. I'm not mutilated. I look fine. And you're like, oh, okay, I didn't mean, so just let them tell their story and figure it out. And on the opposite side, there are, from my perspective, there are employers, there are counsel who represents the employer and insurance carrier, and you have to prep that client because you acknowledging the traumatic experience or injury means your client's looking at you crazy and they think that you've given up on the trial or you're being too friendly or too compassionate. So I think you can't go wrong prepping clients on both sides and setting that expectation to say, hey, this judge really responds well if we at least acknowledge it. And then also, if we do lose or it is, perhaps the person wants to settle the case, we might get a better value if we don't look like. So there's just a lot of chess, I think, that we can't really go into here. Sorry about that.
Yeah. Well, that's actually a segue into something that I guess you were the keynote speaker talking about trauma, trauma-informed lawyering and vicarious trauma, and the way that working with people who are injured um, is taking on, and you're talking about spending hours and hours with people and their families, and with this sense, I think, given in plaintiff's work, that what happened to you was wrong. Like we're all in agreement about that, and so just sort of taking that on is a lot. And I wonder how you handle it, and then Judge, also, for you having to, always be the calm one in the not being adversarial. But maybe Austin, we can start with you.
Sure, yeah, and I think to your point, Miriam, a lot of it has to happen. You have to internalize your client's pain. You have to understand what they went through, and you have to kind of be a vessel for that in order to tell the story. So that part of it, taking it on, is almost inevitable. It's going to happen if you're going to do your job effectively. You have to understand it, you have to internalize it, and then you need to convey it. And it's a lot. It's a lot when you're dealing with parents who have lost a child, people who have lost limbs, people who have been scalped, or the victim of police brutality, who now just don't trust the entire system, not just the police officer who did this to them and then charged them with resisting arrest, but also the judiciary system and you as a lawyer, because you're part of it. It's a lot to take on all of these emotions as an attorney, and you need to take care of yourself first and foremost. You can't pour from an empty vessel. You can't give if you're not taking care of yourself. And the ways that I do that personally is I take time away whenever I can, be with my family. I work out, I meditate, I do whatever I can to take care of myself first, because at the end of the day, if I'm not doing those things, it's a disservice to my clients. And that's something that I learned very early in my career at the public defender's office. You have hundreds and hundreds of cases. You can be there 80 hours a week, and you can burn out very, very quickly. And I saw it happen to a lot of my clients, a lot of my colleagues. So I think when you get out and you start practicing, it's something to keep in mind from the jump, because you can really burn out quickly if you're not taking care of yourself.
And Jonathan, do you have thoughts on that?
I do. I I agree with everything that you just said, but I want to add one important feature, which is setting boundaries. We don't talk enough, I think, in life about the healthiness or the good thing that boundaries can be. And we aren't equipped to actually provide mental health care to our clients, and that's not our job. And so we need to be very clear with our clients and in a caring way about what we can and what we can't do. We don't want to take on an obligation that we can't fulfill, because we'd actually be hurting them in the long run and hurting ourselves. So I think that's the first thing I would add. The second thing is that our firm, for some of the projects we work on, so I co-lead the social media litigation practice at Motley, so we represent families of young children who have either killed themselves or attempted to kill themselves or have gone through some other trauma as a result of social media usage and addiction. We've also represented folks who have been victims of terrorism attacks. So some pretty intense stuff. And doing those intakes, we actually invest in mental health experts to come in and meet with our teams, to have a venue, almost like a group therapy session for the people who do those phone calls, who make those phone calls on the intake level, for the lawyers who are talking and living in this sort of misery for day in, day out as part of their job, providing both a formal outlet for them and then creating other avenues for them to deal with some of that association with trauma, I think, is important. But I think it really, for our clients, as well as ourselves, setting boundaries, right? You want to be there for your clients, but you don't want them calling you in the middle of a Sunday afternoon with a mental health problem, right? It's a different thing than having a client being accessible to a client to maybe stem some anxiety stemming from the litigation itself, right? Someone calls me up and says, I'm worried about this thing in my case, I'm willing to take that call and answer that question. But if they're calling me because of something related to how they're dealing with the trauma, I'm not equipped to handle that, and I've got to set that appropriate boundary. So I think that's really important.
Yeah, I want to underline a piece of what I think you both are referring to, and that is the fact of being a professional. And you tell me if you agree with this, but I was actually talking to some of my colleagues in the firm about we do medical negligence, representing people who are injured and by hospitals and doctors, and I think the other thing that people who've experienced trauma can benefit from is knowing somebody, like, here's this piece of what you're dealing with, and I got it, right? Like, I'm not equipped to be a therapist, which you're still kind of doing that, and you got to get your head around that and figure out how you're going to navigate it. But there's this other piece, which is, okay, here's a part that I can I can show you. I can, literally show you. We're going to go over to the courtroom, but I can also tell you here, this is going to happen, and then this is going to happen, and then for this whole time, you're not going to hear anything. So, and if you have questions, call or whatever. But that is, knowing that it's like if you've ever been to a doctor who's just all nuts and bolts and isn't like all touchy feely. It's like, phew, they're just dealing with the thing that I came with, and I don't know if that resonates with you guys, but
It absolutely does. I mean, part of this too, and sort of a corollary to that is one of the things I like to do to take stress off of my clients is to let them know that they don't have to prove the entire case themselves. So many people think that they need to be more than just the injured plaintiff. And their role isn't more than that. Their role is to just be who they are and talk about what they know. And that can actually be disarming and liberating if all of a sudden that person realizes they don't need to know any of the medical stuff. They don't need to justify any of the medical decisions that they made. Life becomes a lot simpler. And so doing all these things that in our professional role remove stress from people, I think is an important part of the job. But maintaining those sort of professional lines.
Yeah, and I would agree with that, and also add it's the professional lines, and then also establishing expectations. This is what I can do for you, and this is what I cannot do for you, right? And this is what you can expect as we go through this process, what I'll need from you and what I won't need from you. And getting that out at the onset with clients, I think, is important. Because if you get to the end of the case and they're expecting you to change the entire police system or the entire medical system and it's not being done, they're going to be angry. Why'd you bring me through this? I thought this was going to happen, and now all you can get me is money. And realistically, that is all we can get for our clients at the end of the day is monetary compensation. And we can enact changes through that. But you have to set those expectations both in the relationship with the client. I'm not available on the weekends. I'll take your call on Monday. I'll get right back to you. But also with this is what the outcome is going to be, and this is what I'll need from you. I'll need you there for interrogatories. I'll need you there for a deposition, and I'll be there for you if you have questions. I'll be as accessible as you want me to be. I'll keep you as up to date as you want me to. But having managed the expectations and the boundaries, I think, is important from the onset, and that will make the client-attorney relationship a lot better throughout the pendency of the case.
yeah, the one way that I've used to describe that, the sort of try to anticipate the client disappointment, is like, I say to clients, if this is justice, this is what the law can do. It can get you partway there. It's never going to get you all the way there. You're not going to have your child back. You're not going to have your, they know that, right? But it can help, and then it's also visual, so I think it's a thing to go back to. Can help along the way. So, Judge, let me go back to you with this question of managing the effects of day after day, seeing injured people, having to navigate contentious attorneys,
It's
oh my God,
well, it's
metal.
I never the job these gentlemen do and you guys are going to do is a very heavy job in general. I would equate my job to It's just a job of surprises. I don't get the ability to decide who I'm representing. I don't get the ability to decide the cases that appear on my docket. A lot of times lawyers are holding their cards a little close to their vest regarding the exact severity of the injury. I'm not seeing some of the disfigurement, the scarring, the accident scenes. I'm not doing a site view and tour at trial. So I'm not seeing these things until they're really introduced into evidence if it's a severe case. So a lot of times it's difficult for me to discern. I can kind of tell based on what the allegations are, but then like on a Thursday, they're like, we have this horrific thing we're ready to like show you. And you're like, oh, I didn't realize this was coming. Usually I can address this by making sure I have clear scheduling with the attorneys, not putting cases that are going to be extremely draining on the staff and everyone else in the middle of the week when we're surrounded by a million other things, not putting contentious lawyers on the same calendar with contentious lawyers on the same calendar with contentious lawyers, controlling my schedule in a way where I'm not draining everyone's energy in the room, including my staff, my clerk, the sheriff, the steno, and just making sure that I set boundaries. But the boundaries I set are generally relegated to how professional the parties are with each other, what I expect for scheduling orders, and most importantly, and I don't think this is brought up enough, chamber conversations and bench conversations, setting the parameters for those is vital as a judge. Because some lawyers just think because it's not on the record, they can say anything. The problem in our court is I'm issuing a bench decision. I'm the fact finder. So if you come up there and you're like, I was on the phone with my client and they're crying, they can't pay their bills and their legs getting, I'm like, whoa, 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 whoa. This is not an appropriate complaint session. And the other side, frankly, should have an issue with this too. So it's just setting those parameters early will keep me from burning out. And I need to keep my eye on the prize. I need to make sure little things like my face control is good, right? You ever seen a judge with a shock face because they're seeing something horrific? It affects the trial, right? One side is like, yeah, the other side. So it's just controlling yourself, giving people time, having the appropriate reaction to what you're going to see, preparation based on what I'm able to prepare for the evidence. These things keep me sane. It's when it's a complete surprise or people are not prepared or worst case scenario that I have to deal with are when you have horrific injuries and the defect is procedural, right? Like it's like a horrific injury, someone's gone, their wife or their significant other's there, and the reality is someone filed and missed the statute of limitations or there's a notice issue. And then you have to deal with that. I have to rule on it as the law dictates it. But am I going to lose some sleep over the fact that everyone agrees this person had a traumatic death at work and then someone missed the statute of limitations by 6 months? How does that happen? So I think it's scheduling, clear communication, and I also think I talk to a lot of judges about this. I don't have to tell you exactly how I'm going to decide because I don't know. But you should not be guessing how I feel about the way you're practicing. If you're practicing based on the rules I clearly laid out, your arguments are clear, what you're seeking for relief is clear, your defenses are clear, I'm happy with the way the trial is going, and I'm capable of making a decision that I think is based on the evidence. If everything's foggy, you guys are fighting, I don't know what's being said, I don't understand the witness, I don't understand why you even called these three witnesses, that's when we have it's emotionally trying, everyone's mad at each other. Bad lawyering leads to really unclear decisions, which will keep me up at night. So,
Yeah, thank you. Yeah, it's definitely a tough job. And what you're talking about with respect to, like difficult evidence that's going to come in and you don't know until the day before. And okay, now judge, we have the pictures. I think of with jurors, right? And you guys are picking juries, and we all, and you do that too, right? And I wonder if you can, and I'm sorry this wasn't in the notes, but spring it on you. How do you, well, a couple things. One, how do you do voir dire to identify people in jurisdictions that are not really favorable to voir dire, like Massachusetts, so that people are able to show up without being with their whole selves. I mean, we've heard a lot about how trauma kind of cuts off your ability to even hear and take in information. So how do you do voir dire, and then how do you prepare jurors for difficult evidence? So I don't know which of the trial attorneys want to take that first, but.
So, first of all, in any catastrophic injury trial that I've done, we're very judicious in the use of photographic or video evidence. You want to be somewhat sensitive to both your client and to the jury. But I directly ask that question if I have attorney-driven voir dire, or even if I have voir dire through a federal judge where you can submit questions in advance, I want to know, can you see the site of blood? If we show pictures of injuries, is that going to be an issue for a particular juror? So I'm very direct in my voir dire, asking those sort of issues, and I want to find that out because it is part of the case. Some photographs need to get shown. They're relevant to issues of causation and damages, and it's as hard as I try to be judicious in the use of those photos, they still need to be shown, and I can't have somebody who's going to viscerally react to them on my jury if they're going to shut down because of it. And so we ask that question. In a lot of the trials that I do, we do a lot of jury research in advance. In fact, last week I spent 3 days in a focus group on a case I'm going to try next year. And we test out a whole bunch of issues, and ultimately, before most of the trials that I do, we come up with a supplemental juror questionnaire. We reach agreement with the defendants, and usually our juries answer 20, 30-page questionnaires on various issues related to the case so that we can get a better jury.
Yeah, and I agree with what John's saying. You want to get out ahead of it, and you want to know, because you want a fair jury. You want them to be able to remove sympathy from the case and decide it based on the law and the evidence, right? And you need to ask the question, can you see this evidence and view it fairly and apply the law to the evidence and make a decision from there? Or are you going to go to sympathy if you see a picture that depicts a bloody arm or something of that nature? So you need to know. You have to ask the question. There's no getting around that. And as far as being judicious about the evidence that you're putting in, if you're putting in graphic picture after graphic picture after graphic picture, you're not doing yourself any favors. You want to hold back as much as you can, show them what you need to show them, because if you're showing picture after picture after picture, eventually they're going to get it in their heads as the jury that you're actually looking for sympathy, and you're doing that to infuriate them, and they know. So I agree with both points that John made on that.
And a couple practice pointers. One is that sometimes the defense may make the decision to just show so much that people become inured to the reality of what happened. Some of us remember the Rodney King case. That's what they did. It was really clear. And with respect to jury questionnaires, I just want to note that in Rhode Island, the federal district court has a great archive of all kinds of materials that are used in cases, and I think they have questionnaires as well. And you can also do a motion in jurisdictions that are not as favorable, and if you ever find yourself in that position, feel free to contact me, because we've done that a lot in Massachusetts. So let me ask you about more sort of social and systemic trauma that clients may have or jurors may have by virtue of their assigned status in society. In particular, people of color often, they do face inequities in the civil system, and when it comes to fair treatment and fair compensation, and how do you address those issues when representing clients or judge and litigants before you? How do you account for that trauma that's sort of before they even experience the event?
So I'm on the Committee for Racial and Ethnic Fairness in the Courts in Rhode Island, and while I can't address that or really comment on that in terms of, in particular, trial context, What I do, I think, works across the board is I take my position as educating them on the procedures and the orders and the decisions that I'm making before them and kind of how it works. So if I have someone in front of me, a lot of times lawyers will say, oh, we have this stipulation and this. And I always, is your client here? They're here. If they're there, I don't care if the lawyers say, we've already run this through. I explain, this is what's happening to you. This is what they've agreed to do. This is when they should file a claim for appeal if you want to appeal. And these are the rights that you're losing or gaining today. And the reality is, because I'm trying to get people to have some faith in the judicial system, it's incumbent on me to let them know that I am there working for them. I'm a public servant. You might not like the decision I make, but you're certainly not going to say you don't understand it, right? So I just educate them on exactly what's happening, and I find that doing things that way have led to claimants who have come back or repeat claimants who are like, listen, I lost, but I really appreciated the fact that you let me know. I'm not running from the fact that I'm not finding in your favor or I don't find you credible. These are the reasons that I'm making the decision I'm making today, whether it's a pretrial conference or a trial. And I think, honestly, if you can do that from the bench, and not every judge can do that, it goes a long way into addressing some of the systemic issues, right? Because a lot of people don't trust things because they feel like they're not getting a fair shake. But if you explain everything that's happening to them and why you're making the decision you're making, they might not think it's fair, but they certainly understand what's happening. And I think it goes a long way to getting them to thinking the system's fair. So, yeah.
Yeah, I think from an attorney standpoint, that comes back to a lot of setting expectations. And this is what I can do for you, and this is what I cannot do for you. You know, I can't change the fact that this is an unfair system in a lot of ways. I can tell you what the rules and the law allows me to do for you, and I can do my best to get everything done that is in my power to get done for you on this case. But there are certain things that I can't change. And I wish I could, but I can't. So that's the relationship you have to have, and you have to set those boundaries and expectations at the onset. But you also have to understand that these people are coming from a place where they feel like they've been victimized, and in many cases they have, and explain what you can and cannot do. So I think that's the way that I would handle that situation.
So, from my perspective, as I've tried a number of lead poisoning cases, both against landlords and against the industry that made lead paint. In Wisconsin, we won this decision 20 years ago almost, that allowed a form of market share liability against the companies that made lead paint. And inevitably in those cases, the defense was always the apple doesn't fall far from the tree argument, right? The parents were not educated. So this kid wasn't going to amount to anything anyway, so who cares about a little brain damage, right? That's the unsaid part of it, and there was a big racial undertone to all of it. And I will tell you, the first time I tried a case in Wisconsin in '07, they had yet to adopt Daubert, and so we had filed a lot of motions in limine, and we were not successful because they used junk science to get it in. But since then, Daubert has been adopted in Wisconsin. Daubert is obviously the standard here in Rhode Island. And we use science to our benefit. And we file a lot of Daubert challenges, and we file motions in limine, and we keep the garbage out of the case. It has no business being in the case. These notions of the apple doesn't fall from the tree, there's no truth to that. The school performance of siblings has no evidence, no basis to weigh in on my plaintiff, right? So we systematically pull apart the evidence that's going to be supportive of those biases, and we try and get rid of it with science, get rid of it with motion practice, And then when I pick a jury, I have a copy of Batson with me every single time. And I've made some successful Batson challenges because I wish we lived in a colorblind world, but we don't. And when I'm representing folks, I want to make sure that they get a fair shot and they get the best shot at winning. And so I come with my Batson case, and I'm prepared to make a Batson challenge if I need to. And, we have been, except for that one experience in Wisconsin, and I will tell you, it was terrible. We heard things about criminal behavior of distant cousins and all sorts of stuff. And I'm surprised I didn't get locked up with my on the record statements post-trial because I thought it was an abuse of the judicial process, what the judge let in. But we haven't been stuck in that situation anywhere else. Judge Gibney has issued some wonderful decisions blocking that kind of junk science here in Rhode Island. Some of the other jurists have equally put in some really good decisions on that, and I think the boundaries of what is relevant, admissible evidence speak for themselves, and we've got some great jurists in the state who really want a clean trial, and it's our job to make sure that it is a clean trial as an advocate.
Yeah, and I think this underscores the obligation that attorneys have to know, and not just to know, but to really understand the impact of discrimination and prejudice on the people we are going to represent, the jurors, when we're going to try cases. Because you can't really make those arguments unless you have developed some kind of understanding of why that's code or what are the implications of that. All right, well, we only have a few minutes left, so I wanted to open it up, and I'm expecting questions. So not like the nice like those other moderators. So yeah. Be an awful law school professor.
Great panel. Thank you so much. Your Honor, I have to say there's very few judges who approach their work on the bench the way you are, and I just really appreciate the way that you're trauma-informed in how you run your courtroom and support your staff and everybody on your team. I'm curious, I have a question for you, and then I have a question separately for the other attorneys. For you, have you seen any movement among judges to adopt, like you run your courtroom in a very trauma-informed way, have you seen that more broadly? Is there training for trauma-informed practices?
Yeah.
I'm just curious about
Yeah,
that.
so there's been there's voluntary training on it. Do I see this widely being adopted, at least in this jurisdiction? I'm pretty blunt, no. We all run our courtroom so different. And the good thing I'll say is we all talk about this stuff. So I have plenty of friends with judges. We all talk. And the reality is that I think that that's a win, the fact that we're having a conversation about this in the first place. Because if you would have asked me 8 years ago, before I got on the bench when I was practicing, I would have just laughed and said, I would not bring this up, but people are having the conversations. I am aware of judges who factor in these things and try to run their courtroom that way, and I'm aware of judges who don't, but we talk about it, and I think that goes a long way, so.
That's encouraging.
Yeah.
I'm glad the conversations are starting to happen. And then a similar question for all of the attorneys is, does your firm do trauma-informed training? And if so, what does that look like? And if not, would you like training?
We currently don't have an actual program that does trauma-informed training. I think a lot of it comes down to, we do seminars within the firm for all the attorneys, and trauma-informed lawyering is one of the things that's discussed, although it's not an actual, these are the classes that we're going to do within the firm. I think a lot of it also comes down to interpersonal relationships at our firm. Everybody operates in sort of pods. So you have a direct supervisor you can go to, or a peer on the same level that you can go to. And it's very much encouraged that if you're dealing with something, have a conversation about it. Don't just keep it to yourself or try to power through because you're the gladiator on the case. So that's currently the way that it's dealt with at our firm.
My firm has a number of different practice areas, practice groups, and depending upon the practice group, we do bring in outside assistance. So in our social media litigation, we have a trauma educator and a psychologist who come in, work with our staff. We actually just interviewed somebody, and we're looking for someone else to, as we expand our practice representing victims of sex trafficking and other sex crimes, we're looking to make sure that our staff is as protected and prepared as we can. So that's something that we're always looking to do. And certainly if someone's doing securities cases, it doesn't make sense for us to do those sort of folks, provide trauma for them. But But for folks who are doing personal injury work, yeah.
Yeah, we don't, and my firm is very small, well, for attorneys, it's considered medium here. And we don't, and I think the whole, there's this tension that I think came up earlier, maybe when you were speaking, between, being empathetic towards your client, but boy, you tough it out, like no crying, right? That kind of thing. And I think that's, I don't know about you all, but I think that still really exists. And it's very unfortunate because it because good people can be alienated from the practice because there's just there's no quarter from that, and that's really problematic, I know when I was in law school, a public defender came to give a talk, and she talked about how, and there were like no women then being public defender, and this was in Philadelphia, and she would, every morning she'd go into City Hall where the courtrooms were, and go to the ladies' room and throw up, and then she'd go try cases, and that was like, yeah, she's cool, and why am I doing this, So and I think that attitude still, I think it persists.
I think it's the rule, not the exception.
Yeah,
Yeah.
I think you're right.
Did you notice, Miriam, in your experience, that the cases that cause the most trauma to the lawyers are the ones where a lawyer self-identifies with the client, right? It could be, a family where you say, "Oh my God, but for the grace of God, that would have been my dad, or that could have been me." Or it's not every client that makes that personal impact on your life, but it is often enough, and it's the ones that could have been you. I think that for me anyway, that caused the most harm. I don't know if that's your experience.
Absolutely, yeah. No, I remember a case of a young guy who went in for scoliosis surgery and never walked out. And when he went in, he was the same age as my son was when I was at the time, and it was just was so hard. It's just so hard. But you have to let that in, because that's how I think also what you were talking about, you just take it in and you get close and then you have to find a way to, breathe and separate and then carry on. It's not for the faint of heart. Any other questions? Okay, well, I think we're at time. So I would ask you to join me in thanking our panelists.